Hi, everybody. Welcome to Trial Alchemy. And today I'm delighted to have as my guest on Trial Alchemy Richard Schoenberger. He goes by Rich. And Rich is a remarkable lawyer. He's a great guy, great sense of humor, but he's had tremendous success in his almost 40-year legal career. His success and presence in the courtroom has made him one of the most highly respected trial lawyers in California. And Rich was inducted in 2024 as a 37th member of the California Lawyers Association Lawyers Hall of Fame. At various times in his career, Rich has held or shared the record for the largest verdict in different kinds of cases in places like San Francisco, Sacramento, Santa Clara, San Luis Obispo, San Mateo, and Sonoma counties. That's great. So now, when you're getting ready for these trials, and that last trial you were describing, it was a long trial, maybe the longest in your experience, but how do you get ready when you finally know, okay, this one is going to trial? And what's your process? How do you get ready to go so you're ready to go when the judge says, let's bring in a jury?
There's sort of a couple answers to that. The When the judge said, let's get ready to go, let's bring in the jury, that means being prepared with the stuff, knowing your local rules and knowing what she's going to want. Your motions in limine, your list of witnesses, your exhibits, your voir dire, your questionnaire, all the shit, pardon me, all the stuff that you're gonna need to file. And
Yep.
you want to file it just like she wants it, so that you go in looking professional and ready to go. And that's a group effort. That's a if
Right.
you have the luxury of having a few people help, that's important. But in the practical sense of getting ready for trial, there's two things that sort of jump out at me. One, I do a good facts, bad facts analysis, and I have my closing argument essentially written before anybody's doing an opening statement. Because if it isn't going into your closing argument, it's not going into the trial, is sort of the way I look at it. And so then you know where you need to go. So it's like writing the last chapter of the book, and then you get there.
Yep.
That begins with developing your theories and a theme that you're going to stick to. The thing that is more important to me, though, that I do in every trial is I practice jury selection. I never try cases without practicing jury selection. And people talk about um, opening statements and rehearsing it and all that stuff. And I believe in that. But if you're going to rehearse your opening statement and you're going to be asking questions that are sometimes hard to get out because, I'm not alone in that my philosophy in jury selection is I want to empty my worry basket. That's the
Yep.
way I look at jury selection is
Yep.
what am I concerned about? My mini opening is going to highlight those things that I'm concerned about, wrapped in why we win. Parenthetically, I'm going to make sure an associate who doesn't have enough ABOTA points or many is going to give the mini opening so that they can get ABOTA points, and I'm going to make sure they put on a witness so that they can get ABOTA points.
That's
And
great.
and so I work with them on their mini opening, which I'm not saying you want to lose it, but you're not there to win it. And I think too many defense attorneys take their opening statement and shove it into 3 minutes and don't appreciate its purpose. And so, and then I will practice jury selection with 10 people, 12 people, informally, inexpensively, sometimes in a more fancy pants focus group, sometimes not, just so I can blah, 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 say the words about the issues that are unique to this particular case. And I practice listening because my goal is to do about 10% of the talking. And
Yeah.
so that's the most important part of the trial, as far as I'm concerned, and the part that I devote the most attention, well, yeah, you could say the most attention to.
half an hour or 15 minutes?
Hour and a half.
Okay.
Yeah.
You're really covering a lot of things, much maybe more than the judge would let you cover in the courtroom, but you want to just get practice asking lots of questions.
Yeah. One of the hardest things is the first 3 minutes.
Yeah,
And we don't try, I'm supposed to start a trial on November 2nd. I tried this case. I think I picked the jury at the end of, the late of July. It had been a year since I'd picked the jury before that. And time goes. And, when I was a deputy DA, I think I tried 18 cases in 3 years. So you're just going kind of back to back to back. That's just not the way it is here. So
right.
you sometimes just gotta, you have the muscle memory, but it's good to loosen it up, and it gives you confidence going into actual jury selection. So even if you're going to be more than, a judge might give you 45 minutes or something, or
Right.
an hour at the most, or um, yeah, just talking about it and hearing things and practicing how you say things, active listening, bouncing ideas off of, and then um, converting your questions from open-ended to leading to get your cause challenges to, and even your physical movement when you're getting cause challenges, and how
Yeah.
you're, what I'm saying, you're being less confrontational, but your words are confrontational. So we can agree in a folksy way that, at least with respect to this, it's hard for you to be entirely impartial, as opposed to, and you can't be impartial about this, can you? I mean, you're much more likely to say yes to the former than the latter, but the words mean the same either way. And if you can, and entire impartiality are buzzwords under the civil code for purposes of express bias. So um, I just find that the more you can sort of do that ahead of time, every cause challenge you get, you've saved a peremptory, you've made a difference.
Big
Um,
difference. Yeah.
so,
Now,
so
now when you're get a juror in the courtroom and you think there may be a challenge for cause, the way your conversation is going, you know darn well that even if you get them all the way down at the end, the judge is going to try to rehabilitate them and try to keep them from going out for cause. So, what do you do to try to seal that door shut?
well, first of all, I can't remember the name of the case. I think it's Lombardi, and it's from 1899, and it stands for the proposition that you cannot rehabilitate someone who has admitted to that they're biased, or that they
Right.
can't be impartial. Um, and so with a brief, we educate judges with respect to that. We also, I think, you go in with a certain sense of credibility by being prepared, by
Yep.
not wasting time, by getting to the point, and then earning a little bit of the respect of the judge that you're not wasting time, and that they will, give you a little bit of a break. Um, and I have found that most judges are pretty good with cause challenges. They take it seriously, as they should, because they want a fair jury.